We don't want you rattling papers. Oh, yeah. Right? Yeah. All rise. The Honorables, the presiding judge, and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning. Welcome to the North Carolina Court of Appeals. We have one case on for argument this morning, State v. Brown, Court of Appeals 25-44. I'm Jeff Carpenter. I'm the sitting in the middle today. So I'm the senior judge on the panel. To my right is Judge April Wood. To my left, Judge Fred Gore. And Dee McCaskill is doing the honors of being our clerk today. And we've got the very astute Tom Salou as our marshal. Is the appellant ready for argument?
Yes, Your Honor.
Wish to reserve any time for rebuttal?
5 minutes.
5 minutes for rebuttal.
Good morning, Your Honors. May it please the court. My name is Dan Blau. I'm an attorney here in Raleigh at the Blau & Hinson Law Firm. With me today is our associate, Emily Maggio, and it's a pleasure to be with the court this morning to speak with you about Garrison Brown. Your Honors, the alleged victim in this case, J.B., had a history of dreaming about being raped. She also had a history outside of this case of not being able to determine if her memories were real or if they were actually dreams. One day, J.B. accused her cousin, Garrison Brown, of raping her. But then she started telling people that what Garrison did felt like a dream and might have been a dream. She told her therapist that she might have gotten the real thing mixed up with the dream, and she felt confused. And she also told her father that what happened did not really happen, and was just a dream that had felt real at the time. There was no physical evidence she'd been assaulted, and so there were really only two possible explanations for why JB thought it was a dream.
So, counsel, you touched on, I went through the record. So, are you saying that there was, outside of her testimony, no physical examination evidence offered in trial?
That's correct. I'm not sure that there was even a physical examination done. I don't think there was evidence of that. But yeah, no evidence of injury or pregnancy or disease or DNA, things of that nature. One of the possible explanations was that it was a dream and Garrison had never raped her, and she had dreamed it like she had in the past. The other explanation, of course, was that Garrison did rape her, and it felt like a dream because she was having dissociative episodes where her brain would make her think that it was a dream to avoid her being distressed by thinking about that memory. It was up to the jury, of course, to figure out what the real reason was, but there was someone else at the trial that put their thumb on the scale and made that determination for the jury. And we contend today that Garrison's trial was fundamentally unfair for two reasons. First, because the trial court erred by allowing JB's therapist to give an expert opinion that she was, in fact, suffering from dissociative episodes that had been triggered by Garrison raping her. And second, we contend that this error prejudiced Garrison's defense because the jury probably would have reached a different result absent that error. And as a quick note, to your honors, I'll be resting on my brief with regard to the second issue about the detective's interview with the father, although certainly we're happy to answer any questions the court may have about that issue.
And counsel, what standard of review are we to use in this review?
Your Honor, this is unpreserved evidentiary error, so we're under the plain error standard of review. I know there's been some discussion about that in the briefs, but I would point this case. I didn't list all the thousands of cases in my brief where the court has applied plain error, but we could just look at the Clark. These are all in the briefs. The Clark case from our Supreme Court in 2022, the Toe case from 2012, the Ryan case from this court from 2012 also. These are all cases where we were dealing with sex offense prosecutions and alleged improper expert testimony where there was no objection at trial, and the defendant argued under the plain error standard on appeal, and this court and our Supreme Court applied plain error, and in this case would fall into that category.
And as you know, under the opinion from the Supreme Court, State v. Reber, we have a apparently heightened way of reviewing plain error arguments. And how do you contend that your argument meets that burden?
Well, I unfortunately am very familiar with Reber as the losing attorney in that case. I think the Supreme Court would probably disagree with Your Honor that it introduced a heightened standard of review for plain error. I think what the court would say was that they were just clarifying what the standard had always been that was being misapplied. And what the court in Reber said was when you conduct a plain error review, you're not looking exactly at the effect that the error had on the jury. What you're doing is we have to excise that improper testimony and remove it from the record and pretend it didn't exist. And then we kind of look at the shrunken record that we have, and we have to ask, given that record, would the jury probably have returned a different result? And to answer Your Honor's question substantively about how we meet that standard, before we take a look at the rest of the record, I think one really helpful way for this court to kind of establish a baseline of where the jury was is just to look at what happened during jury deliberations. After the first day of deliberations, the jury's been out for a number of hours at that point. They come back at 5 o'clock that afternoon, and the judge says, okay, where are we? And the foreperson says, well, we're deadlocked, and frankly, we've got people entrenched on both sides, and I don't think it's going to move. And it's not like it was an 11-1 split, right? It was 5-5-2. So this was kind of as right down the middle as it can get. And the foreperson said, I don't even know if it's worth continuing on. But eventually they came back the next day, and they got there, they got to a verdict. But I think what that tells us is, it tells us that any evidence that we're removing from the record, any changes we're making to the record, could have had a pretty profound impact and probably would have on how the jury came out and whether they would have eventually arrived at a verdict. And of course here, we're not just talking about removing some sort of minor evidence from the record. We're removing, you know, what was some of the state's strongest evidence of guilt, which was expert testimony that the alleged victim was in fact suffering from dissociative episodes because of the defendant who was on trial raping her. And given the difficulty the jury was already having in returning a verdict, I think this court can be confident that if that opinion hadn't come in, the jury probably would have either continued to be deadlocked or probably would have come out not guilty.
Is the issue you take with the admitted expert in this case testifying that she had dissociative episodes?
No.
Okay.
And I think this is a very important distinction. Because our case law makes clear that in these types of cases, there's a certain, absent physical evidence, which is where we are here, there's a certain line that an expert cannot cross, right? An expert, or in this case a therapist who's treating the patient, can testify about what that patient says to her, can testify about what symptoms that patient is displaying or reporting, can testify about what symptoms are commonly seen in children who are victims of sexual abuse, and can even testify about whether what the victim is describing is consistent with what's often seen in children who are victims of sexual abuse. That's allowed to come in for corroborative purposes. But what an expert cannot do is really kind of two things. First of all, an expert cannot offer an opinion that their patient has actually been sexually abused, and the expert cannot offer an opinion that the mental health problems that the patient is experiencing were caused by the assault that's the subject of the trial that the defendant is on trial for. And that's because in the absence of physical abuse, or in the absence of physical evidence rather, the therapist's opinion that sexual abuse happened and that the psychological harms was caused by that defendant, that's going to be based just on what the alleged victim is reporting. And our Supreme Court told us in the Clark case that there can be lots of different problems why an alleged victim may be exhibiting behavioral changes or psychological problems. It could be, you know, worst case scenario, the patient's actually not telling the truth or is lying. But beyond that, it could be a normal part of a child's development. It could be the result of unrelated trauma, which certainly this child unfortunately had a lot of in her life. Or it could still be the product of sexual abuse, but just by somebody else. And by tying it to the specific defendant and the specific assault that he's on trial for, the expert is kind of verifying what the ultimate cause of that trauma was. And although an expert can identify symptoms and diagnose disorders, such as having dissociative episodes, to the court's question, ultimately the expert's not in a better position than the jury to determine what the ultimate cause was. And the closest analog in our precedent, and I think the case that directly controls the court's result today, is the Chavis case from this court from 2000, which is cited in our brief. In that case, we were dealing with PTSD, so another psychological disorder that can result from trauma. And the doctor, expert witness in that case, first testified, these are the patient's symptoms. I diagnosed the patient with PTSD. Just like, as Your Honor noted in this case, that the patient was diagnosed with having dissociative episodes. And then the expert went on and said that, my opinion is that the triggering event that caused the PTSD was the assault, you know, the sexual assault committed by the defendant. The case came up to this court, and this court said the first part of what the doctor said was fine. The doctor can identify symptoms and make a mental health diagnosis. There's no issue with that at all. But the second part was not okay. What the doctor cannot do then is you know, give an opinion on what the root cause is of those psychological symptoms, because that's, you know, explicitly or implicitly indicating that the victim's mental health struggles were caused by defendant, and that improperly implicates the defendant is the perpetrator of the crime by affirming the victim's account of the events.
Counsel, so stay on that vein of your discussion, but it seems from the record that there was some efforts by the trial judge to remove the jury and to kind of, clarify this testimony. How does that not cure or rectify the potential confusion by the expert?
Well, I think if we look at kind of what happened when the judge sent the jury out, and I think this is, according to my notes, starting on page 404 of the transcript and kind of continues for a while from there, they talk about this trauma-focused cognitive behavioral therapy, and there is kind of a discussion about this and whether even discussing this type of treatment kind of inherently assumes that the assault took place. And Your Honor's correct, the trial court did exercise a gatekeeping role to some extent on the front end, and that was certainly the right thing to do. And the prosecutor kind of agrees, look, I'm not going to ask Ms. Miller as a therapist, says I'm not going to ask Ms. Miller specifically if a sexual assault took place or if she's making a diagnosis of a sexual assault, and says we won't talk about the origins or cause of the trauma. And the judge says, okay, fine, then pursuant to those guardrails, we'll let her go ahead and testify. And
They
it's
went
true.
a little bit
I'm sorry?
further than that. Didn't the trial court go a little bit further than that? Because the state actually sought to introduce her as a trauma-focused cognitive behavioral therapist, right? And there was that
Right.
discussion about State v. Clark, and they
Right.
limited her to a mental health therapist because the court had concerns if we say it's trauma-focused, then are we saying that if trauma in fact occurred? So it does seem as though there was a little bit more conversation.
Yeah, I mean, I think that was yes, to answer Your Honor's question, and that was a very appropriate response for the trial court to have. I think the problem is that what the DA forecasted to the judge about where the line was that they weren't going to cross, they didn't cross that line. So there was a good, probably appropriate understanding going into it, but that understanding didn't end up being followed. And of course, the defense attorney should have objected, and they did not. But I think that despite, the trial court's good efforts on the front end to identify what some of the problems may be here, that line was crossed, unfortunately, because when the DA says we're not going to talk about the origins or cause of the trauma, that just ends up not being true. And there's two parts in the transcript where we can look at this. The first part kind of starts around page 456 of the transcript. And you may see in some places they reference the defendant by the name Daniel, which is his middle name. He goes by Daniel. So if you see Daniel instead of Garrison, they're talking about the same person. But starting in that point, Ms. Miller is talking specifically, and I think that the DA also, they're talking about JB's cousin. Well, that's of course Garrison, who's on trial. And the expert is talking about, I think the question is asked, did she have a mental process that she was going through when thinking about the incident with the cousin? And the expert says, well, yes, first she would have bad thoughts and memories about what happened, which would turn into revenge fantasies against her cousin, so talking about the defendant. And then if that didn't make her feel better, she would dissociate and begin thinking that the abuse didn't really happen. So it's not just she was having dissociative episodes, it was she would dissociate related to the abuse, and it's making that abuse seem dreamlike because that's what was causing her trauma. And then later, this is starting, it's the next day on redirect at starting at 548 and then going a few pages from there, the expert and the DA are talking about the incidents, and that's how the prosecutor said it. Asked whether JB had described to her whether the incident felt dreamlike, talking about the alleged rape in this case. And in response to that question about the incident, Ms. Miller immediately starts talking about disassociation and says when JB is remembering this thing, it's re-traumatizing her, so she has to disconnect from it. And then, why does she disassociate? She disassociates because it's how she gets through that moment when she's thinking about the incident. So even though the DA had told the judge, we're not going to, elicit testimony about what the cause of the dissociative episodes are, it's pretty clear that that is what ended up happening in this case. There's no practical difference.
So let me ask you a question from an observer, not from your perspective, but from an observer. Could the incident also be what JB described when she testified on the witness stand? She was cross-examined about the dreams. Couldn't the incident also be the expert describing what JB had testified to? The point is, you correctly told us earlier that an expert can offer cooperative testimony to things.
Right. So so the expert can testify, the therapist can testify, I treated JB, this is what she told me happened, and that can come in as a prior consistent or inconsistent statement. Same as a CAC interview when the child goes in and is interviewed by a forensic interviewer. That can all come in corroboratively as a prior consistent statement. I think that
you are arguing, your position is that when the expert said the incident, she was referring to something that was not in evidence before that point, but JB had already testified about the incident in her direct example.
Oh, sure. I mean, she'd already testified, and this is in the context of she's referencing, a page from her report. The DA says, all right, well, if you turn to this page and on such and such day, you met with JB. Did she talk to you that day, about the incident and whether the incident was dreamlike? So I don't know that it matters if they're talking about her trial testimony or talking about what she had reported to the therapist. It was the same report. She reported that.
The point is, if it's one of those direct vouching cases like we've seen in the past where the expert comes in and says, there's no evidence in the record so far, and the expert puts it into the record as the evidence. That's direct as to what the expert said. This is not that. This is, you have testimony about the incident from the victim, and then you have an expert talking about the same incident, and that's kind of, it appears that that's kind of the issue, is what the incident is that the expert is referring to.
Well, I don't think there was any question about what it was. I mean, that was the whole, that was what the entire trial was about in the counseling, was the incident where her cousin had raped her. And they referenced, your cousin, you're having revenge fantasies about your cousin, and when that doesn't make you feel better, you dissociate when you're remembering the incident. I don't think that it matters where the evidence originally came from. I mean, the victim can testify to what. Well, maybe I'm not understanding the court's question.
It does if it could fall into that corroboration bucket, right? If it's already in from some other witness and it could fall in that corroboration bucket.
I don't think that's the case, because the problem with corroboration is that when evidence is introduced for corroborative purposes, it is so that the jury can see that the alleged victim has been consistent with what she's reported throughout. And that's why when the therapist gets on the stand and says, she reported feeling this way or feeling like a dream or having dissociative episodes, that's introduced to corroborate the victim's or alleged victim's in-court testimony. But the whole issue in this case was whether this happened or not, right? Whether it was a dream or not.
Maybe.
And
that's the issue from the defendant's perspective. The state's perspective is that it happened. So there's basically two ways: that it happened, but it wasn't me, or it didn't happen. I think the state is it happened. The state's in the position that it happened, and then the defendant's in the position that it didn't happen, not the position that it happened, but it wasn't me.
Right. I think that the difference between the alleged victim's testimony and the expert's testimony, where the expert goes farther, is that when the alleged victim testifies, she kind of talks about some of the dream stuff, right? But she doesn't say, I was having dissociative episodes, and I was having dissociative episodes because of when my cousin Gerson raped me. She's not an expert, she can't say that to begin with, but she didn't give her own diagnosis, and she didn't tie her dissociative episodes to the rape itself. When the expert testifies, now here's where the expert runs through the dividing line. The expert's not just repeating symptoms or discussing a diagnosis. The expert is extrapolating from that what the root cause of it was. And that's exactly what the Chavis case and other cases tell us that the expert cannot do. That's different than the alleged victim's testimony. It's the expert who's saying, okay, what she testified about and what she told me, these symptoms, these dissociative episodes, let me explain to you why they were happening. They were happening because when she was remembering the incident of her cousin raping her, it's so traumatic to her that her brain is now separating itself from her body and is essentially tricking her into thinking that it was a dream. And you know, I mean, in some ways, this case is, I think, identical to Chavis. We're just, you know, it involves a different type of psychological disorder than PTSD. But in other ways here, we're dealing with really more, I don't know if dangerous is the right word, but subject matter that's fraught with a lot more risk in it, because we're talking about whether someone's memories were real or not. And we're having an expert come on the stand and make a determination about whether someone's memories are true and whether they actually happened or whether they didn't happen. This is fundamentally a jury determination, and we just can't allow a case to be prosecuted that way.
Counsel, would have made it a difference if the expert would have drawn a line and talked about the context of the dissociative episodes between the traumatic things from JB's past and versus the sexual traumatic things, because I guess I have a question as far as whether the different traumas were creating the dissociative episodes differently, or whether would it made a difference?
Well, I mean, that's one of the problems, right, is how do you separate those things out? And I think one of the things that our Supreme Court has cautioned us about is that, you know, medical diagnostic tools are not reliable fact-finding tools in a court of justice. And so, you know, would there have been a way for an expert to say, this particular mental health symptom is tied to this incident, and this disassociation is tied to this incident, and this and that? I mean, I don't know the science. I couldn't tell the court, but I think that if an expert attempted to do that, that would run afoul of the same rules that we're talking about here. I think it would require a change of precedent from our Supreme Court to all of a sudden say that now we will allow experts to tie specific psychological disorders or factors to an offense committed by the defendant that the defendant is currently on trial for. But Your Honor's point is important, because we know that there was a lot of other trauma in this young girl's life, unfortunately, and she, in fact, tells her therapist that she's traumatized as a result of many things. I mean, we know that she's getting beaten viciously by her mother and another family member. Her mother beat her dog to death with a baseball bat. She's been involved in family shootings. Family members are threatening suicide, threatening to kill her. And in fact, this is when she discloses, when her mother she gets in trouble, and her mother is threatening to, quote, tear her rump up. And then she discloses, and it takes the focus from her, and her mother goes off in search of Garrison also. But you know, I think that's one of the problems, is how do we separate out what the root cause is of the dissociative episodes, and there's just no way to do it, or even if there is, that was not discussed at this trial. I don't think that's in the record that we have.
The state makes some argument that this evidence was elicited on redirect, and that the cross-examination invited the error, that if there is error, that it was invited error based on how the cross-examination led to the redirect examination. What are your thoughts on that?
Well, and I see I'm getting to my 5 minutes, but I think that's important, and I'm happy to answer the court's question. As I understand the state, well, first of all, it's elicited on direct to begin with, right? As I understand the state's argument, it's not so much that there was anything said on cross that somehow opened the door to this. What the state is claiming is that it was invited error because the defense kind of participated in redacting some of these medical reports. There was some improper information in there, improper in terms of the jury's consideration, And I think both parties recognized this and said, if this is going to come in, let's do some substantial redactions. And in fact, they worked on it, I think, overnight or during the lunch recess before it came in. And so the state's arguing that because defense counsel participated in those redactions and didn't object to not the report, it was the written therapy notes, it was like a 200-page binder, that the defense then can't complain about the testimony. That's incorrect for a couple reasons. One is, first of all, there was a discussion of, we're going to let this in, but only for the therapist to reference during her testimony. The jury's not going to see it. And in fact, it was never published to the jury that she just references page numbers during her testimony, and the jury never asked to see it during jury deliberations or anything like that. But more importantly, and this is why I filed the 90 supplement with the court, so that the court could compare what was actually referenced in the notes. These are treatment notes from 2 different days of therapy, and in the notes, the therapist writes that JB is identifying her biggest symptoms, which include she's having a hard time believing what happened. She's describing, she thinks, wow, did this really happen? And then on the next day, JB says she's having bad days that start with, intrusive thoughts and shift to disbelief, including thoughts of maybe it was a dream. That's what's in the report, is the things that JB is saying to her. What's not in the report is, after the state elicits the testimony of what did she tell you those days, the next question is, well, tell us about that disassociation. What if anything, did you take from that? And then the expert extrapolates from that and starts talking not about the symptoms, but about the root cause of those symptoms and about the disassociation. So that's not contained in the report that the state says makes this an invited error. I'll reserve the rest of my time unless the court has further questions. Thank you.
Ready to hear from the appellee?
Thank you, Your Honor. May it please the court, my name is Jason Kakamo. I'm a Special Deputy Attorney General with the North Carolina Department of Justice, and I'm here on behalf of the state in this matter that is before the court. So I would like to start by saying Ms. Anna Miller testified for hours over multiple days. She testified under, as we have heard, direct examination. She testified under cross-examination. And finally, she testified under redirect examination, as the court has pointed out. Her 238 pages of notes that she took, some of them that we have currently in front of us, they were redacted, they were pored over, they were dissected, and they were quoted over the course of that testimony over those 2 periods of time. And in all of that voluminous testimony that we have just discussed, there are 4 statements, I would say more likely 2, because they were responses to 2 questions, that we're here today to talk about as being accused of vouching. And those statements arise under direct, and they also arise under redirect, and focusing those 2 pages on the references from pages 117 and 121 from the supplemental that was provided to us. The reason I point that out is because it develops an understanding of the limited nature of this complained error. Out of all that was out there, these are the statements that we're left with. And this needs to be viewed, those statements, in the complete context of all the testimony that Ms. Miller gave, but not only what Ms. Miller gave, all the testimony that happened over the 5 days of this trial, to include JB, to include her mother, to include even at the end of this trial, the defendant exercising his right to testify, to get up and deny what happened. In narrowing this aperture to these 4 statements, we can focus on the words that were said, and we can interpret as they were interpreted by the jury. However, to focus solely on them and just kind of look right at them and pull them out of context, it doesn't allow us to actually see how little importance that they would have had in the full scheme of what it was.
Well, counsel, I guess that's relative. If we would have had the jury knock and come back and say, hey, we got 1 holdout.
True.
But,
I'm sorry, sir.
But that wasn't the case. And I've tried a lot of jury cases where 552, a scintilla could be the value of what tips those scales that we're responsible for balancing. So I hear what you're saying, but your math's not mathing when we really take it serious and put a person's liberties on those scales when we have an identified 5-5-2, equation.
Your Honor, I understand 552, and having tried cases before, I would think to myself that this is never coming back the way that we want to do, right?
I'm just saying, I'm asking you to evaluate your math when you say the value of the importance of the statement could be potentially the difference. We don't know, but that's why we're here.
Correct. And what I would respond is that we can view a close jury like that in the way that counsel would like us to view it as, hey, it could have been this little tiny bit of evidence that did it. However, the way you can also view a close jury is they looked at all the evidence. They spent hours poring over every bit of evidence that was put before them, right? This wasn't a jury that left and 30 minutes back, came back and said, hey, we got this figured out, it's done, right? Because in those situations, as a trial attorney, sometimes you wonder, did they even go back and elect a foreperson before they decide who was guilty? But this is a jury that truly cared about what their job was. They had been given instructions about the credibility of the witnesses. They had been given instructions about how they were to weigh evidence that was given to them by experts, and they spent that time going over it. Now, mind you, it was close, 552 to turn into a conviction. We don't know. And again, one of the things that really puts us in the situation we are now is we don't know because we weren't in that jury room, but we also didn't have the trial judge, didn't have the opportunity to address any of the concerns because I'm going to jump to the fact that our error standard here is plain error, right? And again, that's a frustration that we have.
You guys say it's proper for ineffective assistance of counsel review and not plain error. So are you acknowledging that it is plain error at this point?
I'm going to say that the standard that we have in front of this court is a plain error standard because of what happened and the fact that it was a non-objected to in that situation. And I think when we have said, and Judge Wood, you pointed out, I would kind of concur with you that we were under maybe a stricter or a more stringent under Reber that came out in 2024, that the plain error that we are talking about here, it just does not make it with this. And again, I'm going to go back to how small or maybe minor this was. And again,
on that point, I have a question. So obviously, we recognize from case law that vouching is improper. And so in this case, the defendant's contending that that's exactly what Miller did because Miller had diagnosed JB with PTSD and depression. But when she testified specifically that JB was disassociating and said things like, so when she's remembering these traumatic things, it's re-traumatizing in a way. It feels like it's actually happening now, and she's having to survive this moment when she's thinking about it or having flashbacks about that thing. It seems from reading the transcript that Miller several times indicated that she was having these flashbacks and disassociating, and it seemed as though she was saying these things really happened to her, and that's why she's got this depression and this PTSD.
And it may seem that way, but I don't believe that's actually what she's testifying to. As Stansel tells us, an expert can say there are characteristics that an abused child exhibits, right? We can say that it's bedwetting or it's bad grades or lashing out at parents. And then it can say, hey, I will tell you that in examining this child, they had bedwetting, they had lashing out at parents, they had characteristics. What Stansel does not allow is for that conclusion or that logic proof to make that next leap, which is, hey, A, therefore B kind of thing to reach the conclusion. However, we let the jury make those connections back in the jury room that, hey, I heard these things, the expert told me those things could be this, And therefore, we're going to reach that conclusion back here, but the expert's not allowed to do that.
So, counsel, in light of what Judge Wood asked, why did the expert not delineate that the dissociative episodes were, I guess, she did not clarify that the traumatic things were not the cause of the dissociative behavior. I went back, looked through the transcript, and I didn't see where there was a clear delineation, because this child's been through a lot, more than you'd ever want anybody to go through.
Understood. And I concur, she has been through a
But
lot.
there wasn't a vouching that the being beaten, watching her dog, all the things that were listed and went through, there was no vouching for that being the root cause of the dissociative episode. So how can we put value that the small statements that you said, why wasn't there small statements about that?
Well, and what I would say in response is that it is truly unfortunate that we sit here today and read this transcript about this young lady who, she was only 15 when she testified and had more trauma in her life than most of us would ever hope to have or never want to have. But what I would also say is that it was all on the record, right? All of that trauma that we know about and we're talking about right here, we know it because it was on the record, right?
But there was only a line drawn to the dissociative episodes as it relates to the things related to the defendant.
And I think they're saying, when I think that the counsel points out when she's remembering things or these traumatic things or she's thinking about those things, again, maybe I would want to try to draw a fine line is there's the idea of the trauma of remembering and the idea of the trauma of the event, right? And the line I try to draw is going to be very fine, but the fine line, and it really seems that when she's saying is when she's thinking about these or she's having flashbacks, when she is thinking, she is having those dissociative situations, she is disconnecting it from it. And I think that line makes a difference, but I also think that in answer to your question, were it be that the only trauma that this court heard or the jury heard was the trauma of what happened with Mr. Brown, then the situation would be that they would be forced to assume, oh, the trauma that we're talking about is this trauma. But the fact of the matter is everything came out. Everything came out in redirect, everything came out in cross, everything came out in the directive testimony. And again, we're not going to allow for an expert to say, hey, this is what's caused this, but the jury can go back and say, I'm thinking that this is what's causing it, right? Because remember, in these notes that we're talking about, we're talking about all of these things, but when is she having those kind of things that were in the notes? And the reason I, again, point out the notes and the reason why I talk about it again is because when I did talk about it, and Judge Carpenter brought it up, these things all came in, right? And I think it makes a big deal about how this was on redirect, right? Because again, I do think that this is an opening the door when we start having that conversation, because if you go back to the cross-examination, in the cross-examination, I do believe that transcript number, I'd have to look it up off the top of my head, but the defense attorney specifically asks, oh, you quote, I'm quoting from your report, she's having these symptoms. She's having these symptoms of the size and the biggest symptoms, intrusive thoughts, plotting revenge, and having a hard time. This defense attorney is asking, after already having admitted this into evidence, that what's going on with it. And this really smacks and looks almost directly like the Betts case that we had talked about with the McSwain report of putting this all in and then complaining about it later, what's going on. Now, I will also concede that I don't see anywhere in the record that this was published to the jury, but I also see that it was referenced some 70 times during cross-examination. I believe I wrote it in the exact amount of how many times it was. And
Well,
how many times
counsel
it was.
isn't complaining about the witness actually testifying, right? It's not that the problem is that Ms. Miller testified about her treatment of JB. The problem is the statements which were alleged to have been vouching for the fact that this action actually occurred. And wasn't some of this in light of the recordings that were made of JB actually saying, I don't really know if this happened or not, and
Right.
this, could have all been a dream. There were some recordings of that. So wasn't some of this in reference to those recordings where the child is actually saying it didn't happen?
Well, so when I speak about what counsel is saying is the vouching, I can only rely on what he is saying the vouching. And he's listed out 4 times that he felt that there was vouching by quoting it from the transcript. First one being on direct, and again, I'm hoping I'm answering Your Honor's question. And the other 3 being on redirect. And the reason why I kind of brought that out was because if you read the transcript before and after those, they were really truly referencing and almost quoting those lines that were coming from that report. Now, you are correct. There are times replete in this transcript where JB's testimony is called into question. It's called into question by her stepfather. It's called into question even sometimes by, defendant even calls into question saying, I didn't do this at all. And she's even cross-examined about all this of, hey, do you really remember this? Do you remember the time you said that you didn't remember this? Do you remember the time you told your stepfather it wasn't true? And the reason that I can understand how in that situation you would say, well, that just doesn't really look good for the state, right? It just doesn't look good. But at the same time, the flip side of that is the people listening to all of those inconsistencies, all of those things out there is the jury, right? The jury has heard all of the warts that exist with a 15-year-old trying to relay the information of her trauma. And the reason why I believe that that's important, that it may not be a close case, and even I think if we look back at Reber, I think the Supreme Court even says, hey, this wasn't a close case, is that the fact of the matter is the jury was not locked out of knowing what was going on. In fact, they were privy to all of the kind of evidence that would have been somewhat problematic for the state in that regard. And even after listening to it all, they came to a conclusion. And the conclusion was, we believe what she said is true. We do not believe what the defendant, who exercised his right to testify, said was not true.
I guess, counsel, couldn't it also be argued that they gave a tie to the defendant, they gave a tie to the victim, and what put it over the scale was some of the statements by the expert?
I was not in the jury room, but at the same time,
You wasn't in the jury room,
I know.
but you were just explaining to this court your version of what happened in the jury room. But I'm asking you, let's look at it objectively, because I want to make sure the state's supposed to wear the white hat. So I think in your brief you acknowledge, hey, possibly plenary, but it doesn't meet the second prong.
right, and I would say objectively, what I would say is that we expect juries to follow the instructions that they are given. And in this situation, the instruction was clearly given that this testimony was not to be weighed as testimony to be used for guilt or innocence. And so
But she was admitted as an expert, right? I mean, so we're talking about defendant, victim, testimony, lay witnesses, and then the state produces this expert who is telling us all about the victim and her PTSD and her trauma and her disassociation because of the trauma that she actually endured, right? I mean, isn't that what the real issue is? The fact that we're not just talking about he said, she said, we're talking about he said, she said, and we have this expert who is potentially vouching that what she said actually happened.
we do have he said, she said. We do have an expert, but again, we also have the instructions that we give the jury and that we assume that they follow, which is, and if we look again, I know that council brought up Chavis, and I think the underlying case of Chavis is Hall, which again starts talking about that PTSD. And Hall very clearly lays out, it's not, what you can't say is you have PTSD because it's happened, but you can say you have PTSD and that could be corroborating, this associative episodes could be corroborating to the fact that this trauma took place. And I do again think that we are going to have to look at this in regards to what this jury heard and what they were instructed. And again, I'm going to pull it back again because the lens that we really should be looking through is the plain error lens. And the plain error lens would say, what did the jury take back with them? And would it have been enough? And again, what Reber gives us under plain error, it says the words probable and possible, but it also gives us synonyms. And the synonym that it gives is almost certain, right? That's a synonym that is brought from thesaurus in the Reber holding and saying, if you want to know what we mean by this, it means the synonym of almost certain. Is it almost certain that in excising this, that this outcome would have been different under the second prong of Reber? And I don't think with the instructions that were given by this court, the fact that this was corroborating testimony, the fact that they heard everything else, that this is the evidence that put this over the edge. I cannot say that that is an almost certain that there would be a different outcome to that case.
So let me ask you that in light of that statement, are you saying that the 5 jurors that were on the opposite side of the state's requested verdict were wrong because they were interpreting the instruction incorrectly based upon your context?
I would say that they're going to be in conversations.
Because there were 5 initially that did exactly what you said, right? Took the instructions, took the he say, she say, took the expert testimony, and initially were not guilty.
I think juries, over the period of time that they deliberate, change their mind as they...
No, I'm asking at that moment, were they wrong? Because they did what you just said they were supposed to do.
Mhm.
They took the instructions, they took the he say, she say, and at that moment, they were not. So were they wrong in that moment?
I don't know if I would say the word is wrong. I would say the word is they lacked the context and they lacked the time to review what they needed to be able to reach the conclusion that they ultimately reached. Because here's what I'll say. When you walk into a jury room, I don't know, I've never served, but at the same time, you're coming in with your preconceived notions of what it is, and you have your own ideas before you talk to 11 other people and what they heard and what they see and what they do. And sometimes in groups, you make assumptions that maybe you shouldn't have made or something along those lines. So would I say they were wrong? I don't know if I go that far. Would I say that maybe they had to refine the way that they looked at the evidence by having conversations with others in the room? Maybe I would say something along those lines.
Fair enough.
And then I also think that sometimes we don't talk about, and I don't mean to kind of gloss, but I do want to get back to the Reber standard, is that there's a third prong, right? There is a third prong. And we focus really primarily on the first 2 prongs, and it makes sense, right? Because they're the ones that we can really measure, and they're the ones that are the most impactful when we say words like almost certain. But that third prong that lays out there talks about the fundamental fairness of this, or the integrity or public reputation of judicial proceedings. Now, mind you, I get it, right? Defense or defendant's going to say, well, that's really bad because this public reputation, I'm getting found guilty when I didn't say that. I would say on the other side, the victim would say if it was overturned, she would say, oh my goodness, that's the integrity of this, and the public especially is not. But again, we need to remove ourselves out of that kind of relationship that is a contentious relationship because we have parties that are opposed to each other, and ask, looking from the outside of the public of this, would this be a situation where the public would say, oh, the integrity of this is such that we can't ever trust judicial proceedings? What I would say is that's not here. Again, I would go back to a 5 days worth of trial. I go back to a defense attorney who thoroughly cross-examines. I go back to a defendant who has his opportunity to get on the stand and tell the jury, look them in the eye and tell them what it is that he wants them to know. They also, all that comes out. And at the end of the day, looking at that trial, is this one where the fairness or integrity is at? No, this is a fully litigated trial with a jury that took their time, right? They took their time and came back and struggled. We know they struggled. We heard they struggled because it was on the transcript. And so again, I think that third prong, we may not get to it, but I think it would be remiss for us not to look at it because, again, I don't think we get past the second prong because I do not believe that excising these statements would change anything in the outcome of this. But I definitely think in that situation it would not impugn in any way, shape, or form the judicial proceedings in that regard. I know that there was some talk in regards to the second argument about Detective Sellers' testimony. I did want to bring it out also as well that if we are talking about, and maybe this kind of combines with the two things, we as 5 attorneys are here discussing the complexities of testimony and, well, should she have said this or could she have said that? How is this, what does this word mean, or this word or this phrase? We are looking at it, and again, I think we are struggling to say, is it vouching, is it not? But I would say that that lends it to the idea from the outside that a juror is not going to have the complexity of those types of thoughts. But at the same time, we're looking at Detective Sellers' testimony that was so limited in what it said. It was so limited in how it took. And then at the same time, Franklin had the opportunity to testify and be fully cross-examined by well, he got fully time to tell his side of the story and the reason why he did what he did. I'll kind of sum everything up when I say we have numerous years of case law behind us about what vouching is, right? I think everyone knows that that's something that's not allowed. We have case law that really does a good job of laying it out. An expert cannot testify that a child's abused, right? That's plain and simple. They can't say this child's been abused. Expert cannot testify that they fall into a category of an abused child. And they also can't testify that they're telling the truth, right? So in really simple terms, all of our vouching kind of falls into these types of 3 buckets of things that we don't allow. Were we in a situation where the individual got and said, oh, by the way, I'm an expert and she's been abused? Yeah, we got a problem. And we got a problem that also probably overcomes plain error because it's so direct and it's so pointed in what it says. If we have someone who goes up there and says, hey, I just want you to know this is the most believable person I've ever seen in my entire life and you should trust everything she says, yeah, again, that's really bad vouching. And again, if we're in that situation where that type of vouching takes place, it's something that we have to say maybe plain error is, even though an exacting standard, it's going to overcome it. Really the closest thing that we get to in looking at vouching in this case is the idea is under the Toei or Tui case of that testimony of, oh, would you place her in the category of someone who's been abused? Oh, yes, I would do that in that situation. But that's not even what we have here, right? We're having intense conversations about, well, does she place into a category here? We talk about Hall, we talk about Chisholm. But again, when Hall talks about what you can't say in PTSD, it does lay out that what you can say and what that testimony can be used for. And what I would say is that in this situation, it is almost essentially Hall in that she has said she is having dissociative episodes. And dissociative episodes could be a characteristic of someone who's abused, and then allows the jury to make that final conclusion. And that's what she does. She allows them to make that final conclusion. And then again, I would also note that would it be that any of this were to be something that may rise to the level of error, I do think it's important that we look at how this was brought to the attention of the jury through the testimony. through the actual statements, through the client progress notes that were brought into evidence, that were talked about, that were quoted, that were spoken about, and also in the evidence in regards to how cross-examination went between the two parties that brought back the redirect and opening the door. Because again, in that cross-examination, when we were talking about those statements, the defense attorney says, hey, I want you to look at page 117. I want you to look at page 121. And I tell you, you're quoting from, he says, you said, you quote, and then says the statement. And then that, again, requires the state to go back and have further conversation about this. I do believe that should there have been error, there is not plain error, but should be the error would be invited error at this point. And understanding I have about 2 minutes left, are there any questions, not to belabor the point any further from the justices?
Thank you.
I yield the rest of my time. Thank you.
Mr. Fowl,
Thank you, Your Honor.
about 2 minutes and 20 seconds left, I think.
I will endeavor to move quickly. The first thing I'll tell the court is the state brought up the third prong of Reber, that it has to be an error, or that it will often be an error that affects the fairness or integrity or public reputation of judicial proceeding. Well, we can deal with that pretty easily. On page 25 of our opening brief, we cite the Toe case, where our Supreme Court told us that in a case that, quote, turns on the credibility of the victim who provided the only direct evidence against the defendant, vouching error such as the one here is the type of error that seriously affects the fairness, integrity, and public reputation of judicial proceedings. I think it's pretty fundamentally unfair for someone to serve a 25-year prison sentence after a trial where there's an expert talking about whose memories are real and whose memories are not real. So I think we can deal with that prong pretty quickly if there's prejudicial error. Turning to the question of, the prejudice question, Judge Gore, you used the term, it takes a scintilla of evidence when you're 5 to 5 to 2. And I think one thing that's important to recognize is when the plain error test asks if there would probably be a different outcome, that doesn't mean not guilty. It means if one juror holds out and it's 11-1 hung jury, that's a different outcome. And so we don't have to be able to say with confidence, even though we may be able to, but we don't have to say that we're confident that all 12 jurors would have voted to acquit. All we have to say is we feel pretty good that at least one juror would not have been able to get to reasonable doubt. That's what gets us prejudice for purposes of plain error. And, one of the things that the state repeated, in my 25 seconds left, is that this testimony was insignificant. It was part of much longer part of testimony in a long trial. That's always going to be the case in cases like this. And to the extent they say it was minor, it didn't matter, I think that contradicts everything our courts have ever told us about the importance of expert testimony and how juries are very likely to rely heavily on what an expert says. Thank you, Your Honor. Appreciate the opportunity.
Thank you. Nice, timely wrap up there. Thank you both for very good arguments. The case will be taken under advisement, and we will be in recess, or we'll adjourn.
All rise. Court adjourned.